Chair lays out SJR 27 as a matter of postponed business on third reading. Clerk will read the resolution.
SJR 27 by Huffman, proposing a constitutional amendment regarding the membership of the State Commission on Judicial Conduct, the membership of the tribunal to review the Commission's recommendations, and the authority of the Commission, the tribunal, and the Texas Supreme Court to more effectively sanction judges and justices for judicial misconduct.
Mr. Leach.
Thank you, Mr. Speaker. Members, this is the SJR reforming and strengthening the State Commission on Judicial Conduct. I do have a third reading amendment.
Following amendment, clerk will read the amendment. Following amendment, clerk will read the amendment.
Amendment by Leach.
Mr. Leach.
Thank you, Mr. Speaker. Members, I'm sorry for the delay. This amendment, which should be up on your screens, is in response to some of the concerns, the feedback, the ideas that I've heard from some of you, specifically Representative Wu. I want to give him credit for this idea. He brought me an idea earlier. I wasn't able to go all the way, but this, I think, gets us quite a ways to where he wants to go, and I think it's actually good, and it strengthens the bill. What it will do is the 6 appointees appointed by the Supreme Court, this will simply require 2 of those to be trial court judges. And so I appreciate Representative Wu bringing that idea to me, and I'm happy to agree to accept that into the SJR. I think he now has an amendment to my amendment.
The following amendment to the amendment, clerk will read the amendment to the amendment.
Amendment by Wu.
Mr. Wu.
Thank you, members. And I want to say just off the top of the bat, I really appreciate Chair Leach in considering this. I appreciate his willingness to negotiate and talk about this. Mr. Leach has a part of the amendment that I requested, and this is the other half of the amendment I requested. Let me just explain for everyone's clarification what the current law is. The current law says that the Supreme Court has the majority pick for this commission. The Supreme Court of the state of Texas, the 100% Republican elected Supreme Court of the state of Texas, has the majority members on this commission. Out of this commission, there are supposed to be 1 Court of Appeals judge, 1 district court judge, 2 state bar members who are not judicial officers, 5 citizens picked by the governor, 1 JP, 1 municipal court judge, 1 county court at law judge, 1 constitutional county court judge. The reason for this is the following. This commission exists to judge judges. How do you judge judges if you don't have the judges that actually know what they're talking about and actually practice this stuff day to day? If you're going to have a muni court judge be brought in to be judged, and you have a bunch of district court judges or a bunch of laymen who don't understand this at all, how are they to judge what is being done? If you brought in a probate judge acts very differently and behaves very differently than, let's say, a criminal district court judge. And all of these things, the complaints about judges do not just occur in trial judges, they occur up and down the line. They might be as low as your muni court judge who's dealing with your speeding tickets and whatnot. It could be as high as an appellate court judge. The point is, the law that we have written in the books right now has planned for this, has said, if we are to put restrictions on judges, if we are to take disciplinary action against them for not doing their jobs, then the people on the commission should know what that job is. What we have done in this bill so far is flip this completely around. We have given the majority of votes to laymen, to people who are not attorneys and not judicial officers. Okay? And we're asking people who are not in the bar, not sitting in a judicial seat, to say what a judge is doing right or wrong. Members, let me be very clear about the other part of this bill that makes that proposition so dangerous. On page 3, starting on line 22, it says, this is what we're adding to what judges are supposed to be looked at. If after formal hearing or after consideration record report of master, the commission finds, and this is what we're adding, that the person engaged in willful or persistent conduct that is clearly inconsistent with, quote, proper performance of a judge's duties. Here's the thing, this isn't talking about law violations. This is not talking about criminal acts, that's already covered. This is not talking about ethical violations, that's already covered. This is adding a new thing and says, well, you're just not doing what the other judges are doing. How do you know what the other judges are doing unless there are some of those judges on the commission? How? You're going to say you're not doing what others expect, not that you're violating law, not that you're breaking your ethics, not that you've committed sexual harassment, not that you've been rude to and unprofessional to someone else, but you're not doing it the way we like. Shouldn't that point be made by a diverse array of judges? This amendment, my amendment to the amendment, is the other half of what Mr. Leach left out of my original amendment. And that is to say, we should make sure that the people that are overseeing this commission is a spectrum, is an across-the-board cut of everyone who serves in the judiciary, so that we have an idea of what we're supposed to be doing. I don't see why that's such a big deal. Unless the point of this is to just pile political power into one place. I would ask that you, are you going to table? Or? Yes, I'm going to move the table. Mr. Leach is going to move to table this. I would ask you to vote no to table. If this amendment to the amendment gets on the bill, I will drop all my opposition and I will vote for this bill. Right? That's my commitment. That's my commitment to Mr. Leach before he split my amendment part. And it'll be my commitment to you now that I would not only vote for this bill, I would tell others to vote for this bill as well if this amendment to the amendment gets on.
Mr. Speaker,
Ms. Gauls, for what purpose?
does the gentleman yield?
Gentleman yield for questions.
I will.
He yields for questions.
Representative Wu, so can you just re-explain? So your amendment changes the makeup of how, right, this commission will be structured, correct?
Correct.
And just for folks that may not be listening, can you describe exactly what changes it made to how the bill currently has the commission?
So the current law is that a majority of the votes on this commission will come from the Supreme Court. That's the one thing that I want to return, that this is a 6-7 split. We're trying to restore it back to 7-6. That even with this change, one, the governor would still get an additional pick. That pick will be a layman instead of an attorney. But we would still make sure that the majority of votes, by one vote, majority by one vote, belongs to the people who are ultimately in charge of the courts, which is the Supreme Court of the state of Texas, a 100% Republican-controlled organization, a body. And my concern about this, and again, this does not gut the bill. I don't even mess with the part that I have most issue with, which is the additional provision on page 3. I don't even touch that. This does not gut the bill. This does not mess with the bill. This just restores the balance to where it is in the law now. It still gives the governor an additional pick. It still puts one additional layman onto this commission. It does not do anything to the bill other than balance it back to where we have it in the law now. I just want the system to work. I just want it to be fair, and I just want it to. This is an important issue about the separation of powers, about the independence of our judiciary. This is a serious issue. And this is not an attempt to screw up this bill. This is my last-ditch effort to save something of what we have right now, and to make this process fair, and to make it equitable, and to make sure that if we have judges who are censured, who are admonished, whatever it is, that it's done by their peers. It's done by their peers, not by citizens who sit outside who are not even attorneys. For everyone who is an attorney here, you should take this very seriously. This is about the independence of the judicial branch. All I would ask is for the amendment to go on. That's all I'm asking. It's not a lot.
Thank you.
Mr. Bryant in favor.
Members of the House, I rise in favor of the Wu Amendment. I think it's very important for us to realize who we are as Texans and what responsibilities we bear as members of this House. Our state is larger than most countries. We're the size of a nation. And when you start talking about balance of power and the separations of power between the executive branch and the judicial branch and the legislative branch, these are serious matters. We're legislating here for the long term. We're rewriting the state constitution with this amendment. I would say to my Democratic colleagues, first of all, that conditioning your vote or voting for this for some short-term issue, such as been suggested to us in the lobbying of our side, is grossly irresponsible. The decision must be made looking for the long term. And to the Republicans, I would say, bear in mind that there will be divisions within your party, statewide and in the legislature. You cannot count on giving the governor power over the judiciary here, working out the way you want it to, because you don't know who the future governor will be. It might even be a governor of a different party. This bill, for the first time, it changes the Constitution and gives the governor the power to appoint a majority, not of judges, but of lay people to this Judicial Commission to govern the activities of judges. All Mr. Wu is trying to do here is say, let's keep an aspect of what's in the law now, where the Supreme Court, and in the current law, I should say, a repeat of what's in the law presently, where the governor still appoints citizens, but he doesn't appoint a majority of the board that decides how we're going to assess the work of our judges. This amendment would say the Supreme Court would pick 7 of the 13 members of this commission, not the governor. And the governor would pick 6 citizens who would serve on the board. That keeps the power of the judiciary intact in its part of our government. It's responsible. It provides for oversight. The governor has a big say in it because those citizen members are equal members of the commission. But it does not turn power over the judiciary over to gubernatorial appointments of people who are not involved in the judiciary and are not likely to recognize problems without the assistance of members of the judiciary to help them do that. This is a very bad bill unless amended. It's well-intentioned. I have great respect for my colleague and friend, Mr. Leach, with whom I serve on a committee in this House and have grown to have great affection for. But I strongly urge you to make this one relatively small amendment in this bill and leave control over our judiciary in the hands of the judiciary, the Texas Supreme Court.
Mr. Leach in opposition.
Thank you, Mr. Speaker. Members, I'm going to move to table the amendment to the amendment. I ask that you stick with me on this. I appreciate Representative Wu and Representative Bryant and bringing their concerns and talking through them with me, and I feel like I've done my job in meeting them as far as I can on this. Making sure that 2 of the Supreme Court's appointments are trial court judges is it's not a concession. I actually think it strengthens the bill, and I appreciate Representative Wu bringing that to me, but I cannot go as far as he wants to, and so I'm asking you to stick with me and table the amendment to the amendment.
Mr. Wu sends up an amendment. Mr. Leach has moved to table. The questions on the motion to table, clerk ring the bell. Show Mr. Leach voting aye, Mr. Bryant and Mr. Wu voting nay. Have all members voted? Have all members voted? There being 88 ayes and 56 nays, the motion to table prevails.
Gene, can you speak in favor of the amendment? He's going to speak just very quick. Back on the amendment. He's going to speak in favor of the amendment.
Back on the amendment unamended. Mr. Wu in favor of the amendment unamended.
I'll take something over nothing. Please vote for the amendment.
Mr. Leach sends up an amendment. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 142 ayes, 0 nays. The amendment's adopted. Anyone wish to speak on, for, against SJR 27? Mr. Wu in opposition.
Well, members, I'm sorry I have to be here to speak against this bill. I was ready to vote for it. Again, I really appreciate Mr. Leach's work on this. I know Mr. Leach and I have had our fun on the front and back mics, but I respect his efforts to work with us, and I think Mr. Leach was willing to work with us. I think the people who are not willing to work with us are across the hall, and that has been consistent throughout this session. And just like earlier, I think this is kind of one of those expect us moments as well. That this is something that I think we've made very reasonable requests. Requests that don't destroy this bill, requests that don't upset what their intent was, but simply, can we have just a tiny bit of balance? Could we have a tiny bit of, can we protect the system that we have and not do to the judiciary what we have done to everything else, which is politicize it until it's dead. And this is really the frustration for me, because, I mean, outside of my role here, I'm a lawyer, but I'm also a law nerd. You know, I'm one of the few people that really enjoyed law school. And my classmates really hate me for that too. But that's not the point. The point is, what happens to the judiciary, to me, outside of all this, is extremely important. Because the judiciary is what ties our nation together. The judiciary is what ties our democracy together. It's how we make sure that the legislative branch works with the executive branch and works with everybody else. They're the referees who come in and say, everybody chill out for a moment, let's figure this out. The point of the judiciary, if you look at their rules of ethics, if you look at what they swear to, they swear, even if though they run as Democrats, run as Republicans or independents or whatever, that they will not use that in place of their judgment, that they will keep their minds clear and not prejudge issues before they come before them in court. That's why if you go work with judiciary candidates, they go out campaigning, they can't say, they don't talk about abortion, they don't talk about guns, they don't talk about all this stuff. Because they can't. They're not supposed to. They're not supposed to have made up their minds about what happens before it appears before them in court. That is very different from what we do, and I think we can't see that because we don't live in that world. Judicial Commission I understand, is not functioning as well as they would like. You know what would have helped it? Money. You know what would have helped them? More staff. You know what would have helped them? More resources. This doesn't help them. This bill, this SJR, only helps one person, and that's Greg Abbott. And I'm sorry that people don't want to hear that, but that's the truth. We have taken a commission that was made up of people picked by the Supreme Court of Texas, again, a 100% Republican-controlled institution, a body, and flipped it around and gave the majority control to lay persons, people who are not even attorneys, much less judges, and say, you now have the majority control. And people say, well, the Senate's going to figure this stuff out. My friends, the Senate voted this out of their committee 9-0. In the House, it was 6-5. I think you all know what a rubber stamp the Senate is. Come on. I got some laughs out of that. This is not just about politics. This is about our democracy. Having a judicial system that is not afraid to do their jobs is what we need. Here is the danger. Here is the real danger. This provision on page 3. This is not about ethics violations. This is not about criminal violations. This is not about sexual harassment. This is not about being unprofessional. All those issues are already covered. The great fear of this thing, the thing that they're hiding sort of on page 3, that we don't really talk about, is that in the future, if judges, let's say, maybe a judge sides with a plaintiff a lot more than they side with defendants in lawsuits, maybe that judge gets investigated and say, well, that's not proper performance because you're not doing the things we want. You're not doing it the way we want. Is that an ethical violation? Nope. Is it a criminal violation? Nope. What is it? Well, we just don't like it. If you really want to politicize it, that's how you would do it right there. That part right there. And all I had asked for on the previous amendment was this. If you're going to put this kind of ambiguous question of how judges will be judged, at least put the majority of people who will be making that decision as actual judges. And that was denied. I'm asking you to oppose this legislation to maintain balance within our government. Maintain balance. You guys remember that? There is a balance of powers between the legislative, the executive, and the judiciary. Each one checks the other. Here we have a process that used to be set by the Supreme Court, used to be set by the judiciary, and now it's going to be consumed by the executive and the legislative. We have watched this happen again, time and time again. We don't like the way the judges are handing out verdicts, so we created a special court just for large corporate defendants. We don't like the other ones? Well, let's go after them in other ways, and let's make sure that they're scared into doing what they're supposed to do. At the end of the day, this is about Texans versus moneyed interests. I really believe that. That this is about us putting our thumb on the scale when we don't like that our judges are ruling in favor of our constituents, ruling in favor of our citizens, ruling in favor of people who have been hurt. And this is the way we're going to solve it. I urge you to vote no on SJR 27.
Ms. Johnson.
I'm sorry, I'll add one more thing. I know that Mr. Leach has said that this is not tied to the judicial pay raise, but every single one of you, while it is not legally tied, every single one of you has gotten text messages say like, if we don't pass this, then we don't get judicial pay raises? How good is this bill if you have to tie it to judicial pay raises? Think about that.
Ms. Johnson. In favor.
Thank you, Mr. Speaker, members. Chairman Wu and I both have worked in our Harris County Courthouse, and he and I are going to disagree on this particular bill. I've been down in the courthouse for a little more than 20 years, and I will tell you there was a notorious judge that just didn't go to work. You knew if your case got set for trial in that court, it wasn't really going to go because he just didn't show up. And he was a Republican. And he just kept on getting elected, and everybody liked him. What this bill says is that if a judge is just not doing their job, they're not showing up, they're not going to jury trial, they're not giving the accused their day in court, they're not giving the victim their day in court, that the commission can step in. I am the daughter of a judge. I'm pretty biased here. I've seen my mom get targeted, get attacked. I've seen my friends who are judges get targeted, get attacked. I've seen their kids' faces be put out on social media to be attacked because the public right now is in an uproar about our judges and everybody thinks that they know better than them. And that is a dangerous spot for us to be in. I've been critical of this. I've been highly critical of this over the last couple of months on our Judiciary and Civil Jurisprudence Committee, even calling out the governor's office. And the fact that they continually put out on Facebook what I think is misinformation about some of our current judges, demonizing the judges for actually making the only decision that the law could allow. And I'll tell you what, I'm tired of it. I'm sick of it, and it ought to scare the hell out of you. Because these judges are getting death threats because right now we are playing this political game of throwing them out on social media or demonizing the decision they make as opposed to allowing them to do the really hard job they have to do. Did y'all know that they can't fight back? Did you know by the canons of judicial ethics that when they get attacked on social media, they can't fight back? We ask our judges to uphold the highest standard to protect the integrity of the entire system that we trust, while you and I get to come in here as partisan electeds and fight and bicker and complain about policy. But we tell them not to. We tell them to sit quietly, to wear the black robe, to sit at an elevated position over the parties, and to make a ruling that in each and every case, I promise you, both sides are usually upset. I am begging us as a system to get back to trusting our judges and let them be judges. My hope is that the conversations that Chairman Leach and others have been having for months about get off the back of our judges. Let's attract qualified, good individuals. Let's ask them to do the job. Let's stop fighting with them on a partisan basis, and let's let them get back to work. I've also had the honor of representing some in the judiciary before the Judicial Conduct Commission. I've been one of the lawyers to do this work. And I will tell you, we should trust the commission. The commission has a staff, the commission has a team, and the commission is not supposed to be part of a Twitter game. The commission is not supposed to be part of a Facebook game. Representative Holt, you talked about being on the commission. The commission is supposed to raise their hand and take an oath to do a job to help hold the judiciary to account aside from political norms. They are supposed to sit in a closed room and evaluate everything and help us make determinations if a judge is not doing the job the way they should, if maybe a judge just needs a private reprimand, if maybe it's to the point that the public does need to know, if maybe the judge needs training, or in the worst case scenario, the judge is just not doing the job, and maybe there is a need to seek a removal. But let me tell you what doesn't scare me about these conditions, because I'm from Harris County.
Mr. Speaker.
And I will tell you, you guys continually hear about those bad judges in Harris County. And there may be one or two that you might disagree with here or there, but guess what's going to happen if you actually look at clearance rates? Harris County's knocking it out of the park. Guess what happens if you actually look at who's trying cases to jury trials? Who got back up and running in COVID before most other people, and who is really working hard? All of our judges in Harris County.
Mr. Speaker,
Mr. Wu, for what purpose?
would the lady yield for questions?
Is that lady for questions? She yields for questions.
Representative Johnson, I, again, very much appreciate your work on all of this. And earlier, and just now, you said that Harris County judges they're doing gangbusters. They're doing above par work in their county, correct?
Yes, I think by and large.
And right now, even doing above par work in their county, those same judges are being attacked by the public. Isn't that what you said?
Yes, and I think
Okay.
it needs to stop.
And so we're going to take that enraged public who are not attorneys, who don't understand how things work, and we're going to make the majority of this commission now, instead of having a majority be picked by the Supreme Court.
Yes, this bill is going to say that the governor's office, and that's whoever we elect, whoever's elected governor gets to appoint, and whoever's elected in the legislature gets to approve those appointments. And my hope is that we as a body demonstrate the integrity that we expect, that when those people get appointed, that they raise their hand to take an oath, and they are not. There is no suggestion that they are coming in with a political thread, that they are there to ensure that the judiciary works. And for the judiciary to work, people need to understand that they have to make tough calls in tough situations, free from partisanship and absolutely free from extremism.
And Rep. Johnson, I think you've actually been making my points for me, that because these are difficult decisions, because these jobs are complicated, poorly understood, and very detailed, that you should have more judges who actually do the work, who understand what the workload is, understands what the norms are to make that judgment. But instead, this legislation now flips it and says, well, the majority of people who are going to be on this commission are now lay people who don't understand, are clearly can be a political appointment, appointed for their politics, not in spite of it. I think the points that you brought up make my point for me.
My faith is that the folks that do get appointed raise their hand, take that oath, respect the fact that these decisions are made behind closed doors, and intended that we have the most highly qualified and best judiciary. My hope is also that by ensuring that the public is part of this process, that we free ourselves from this partisan game that we are seeing on social media to demonize our judges. I hope that the commitment to our judiciary and the qualifications in our judiciary and the discussions that we have had on this committee for months about the fact that we want to recruit the best and most talented individuals to the bench, and we want them to have a respectable amount of longevity. We want them to have, as we say, a little bit of time in that saddle to figure out the job, to figure out the hot spots, and to find the courage to do the right thing for people. My expectation with making these broad changes with regard to our judiciary, and the acknowledgement that if you do have somebody that just flat out doesn't want to come to work, that there is a mechanism to say, hey, We just need you to uphold the basics of coming to the job, doing the job, and ensuring that people get their court cases heard, not the manner in which the result or the outcome, but that we're in there doing it. And by and large, I fully expect that the judges that I know from across this state are going to meet those hurdles with flying colors. My prayer for this change is that we have a faith in the Judicial Conduct Commission. We get off Twitter, we get off Facebook, and we let that commission do their job under oath. I am going to be supporting SJR 27.
Mr. Leach to close.
Thank you, Mr. Speaker. Members, I think it's time to vote. What do you
Ms.
think?
Jones, for what purpose?
Mr. Speaker, will the gentleman yield for questions?
Gentleman yield for questions.
Yes, I will.
He yields for questions.
Chairman Leach, first of all, thank you for taking the part of Rep. Wu's amendment that you took. I appreciate that. I do agree with you that it makes it better. I've had some judges reach out to me, and I came before the dais and I spoke with you really quickly, and I want for this to be public. About private reprimands, are they allowed under this SJR?
Yes, they are allowed. That is on page 3 of the bill in section 8, where it talks about the Judicial Conduct Commission's retained authority and ability to issue private reprimands. If it is willful and persistent, then at that point it can become public, but absolutely the commission still retains the power to do private reprimanding. It's a course correction. Basically a judge that needs to get back on track, commission reviews the case, tells the judge what the course correction is, gives them an opportunity to course correct, and that's really what the commission's purpose is.
So do you get one course correction? Like maybe if you're a new judge and you continue to get the same types of complaints, I certainly understand that reprimand. But what if you've been on the bench for a long time, you very rarely get complaints, and you get, I don't know, a complaint in 5 years or 10 years?
Sure, that is the commission's discretion. In section 8 of the bill, again on page 3, after such investigation as it deems necessary, the commission may in its discretion issue a private or public admonition, warning, reprimand, or education. And so the commission retains the discretion, as they have now, to issue as many private reprimands as they want, whether they're separated by 1, 10, 20 years.
Okay, thank you. The next question I have, can the Judicial Commission publicly reprimand a judge without giving that judge the opportunity to have an evidentiary hearing?
No.
And so what's the process for that? Because there have been people that have come to me and said, I can be reprimanded and I literally don't have due process. So
the due process, again, is on page, spread throughout the bill, but primarily on page 3 of the bill, section 8, where it talks about a formal proceedings, a formal hearing. It talks about the judge's ability to appear, to have witnesses, evidence, sets forth the procedures. So all of that is in the bill. And I would also, the doomsday scenario that Representative Wu painted about how this commission is going to be disciplining and kicking judges out of office and removing judges, that is actually a patent misunderstanding of what the commission does and what the commission is able to do. There are still judicial review boards. There is due process. There are rights for a judge to appeal decisions of the commission. And so all of that is currently law, and that is retained in the law now going forward after this SJR passes. And so the doomsday scenarios, while I respect Representative Wu, I just think he's misguided and he's misguiding the body by painting a picture of the commission that is just not accurate and will not be accurate if and when this SJR goes into effect.
So I just heard you, so if I'm a judge, I have the opportunity to appeal the commission's wanting to give a public reprimand before they actually do it?
Sure,
Are you telling me that's allowed?
Yes.
Because you directed me to page 3, starts with line 6, section 8. Says, after such investigation as it deems necessary, the commission may, in its discretion, issue a private or public admonition, warning, reprimand. You see that part? I'm not going to read all of it.
That's the part I just read.
Oh, right. I just wanted to
Right.
make sure we're talking about the same thing.
Yeah,
So
no,
so before a public reprimand is made public, the judge has the opportunity to challenge the reprimand.
Of course, yes.
Okay, some people weren't reading it like that. That's why.
Well, I think that's probably true, and I'm happy to answer your questions, Representative Jones. But I also think there was some willful and intentional misguiding and misdirection. What this commission does is not political. It is not partisan. It truly is an additional check on judges who are exhibiting willful and persistent misconduct and therefore not doing their job in representing and serving the people who elected them. That is what the commission does. There are Republicans and Democrats currently on the commission, and that will continue. And so I appreciate Representative Wu. I think the amendment that I accepted that he offered does strengthen the bill, but I think it's time to vote on this. Members, I would ask.
So I just have one final question. Can you just show me, because I don't see it, I know you said it's here, can you just direct me to the section that says if I want to appeal the commission's public reprimand, I have a right to do that before it is made public?
So if it's really all throughout the bill, Representative Jones. If you look on, we talked about page 3. If you look at page 4, section 2, lines 4 through 11, it talks about.
Hold on, page 4. What? I'm sorry, you were talking faster.
Page 4, section 2. I'm sorry, section II, lines 4 through 11. On page 5 of the bill. Sorry, going on to page 6 of the bill, it talks about the temporary provisions starting at the bottom of page 6, lines 23 through 27. All throughout the bill, and we're not changing this part of current law, Representative Jones. All throughout the bill and in current law, a judge's due process rights are protected. There are procedures in place by which there are judicial review boards, and all of that. We're not changing any of that. We're not changing any of that at all. All of those due process rights are still protected throughout the bill.
So I'm looking at Mr. Chair, I'm looking at page 4 under II, starting at number 4. I see where it says, for a person holding an office or position specified in subsection 6 of this section, who has never been issued an order under this subparagraph, and in response to a complaint or report other than a complaint or report alleging the person engaged in conduct constituting a criminal offense, so that carves the criminal offense out, they may issue an order of private admonition, warning, reprimand, censure, or requirement that the person obtain additional training or education. And I don't know that answered my question. My question is there something in here that says, judge accused of a complaint, you have a right to do this before the reprimand is made public? That's
Page 5, lines 5 through 7. A justice, judge, master, or magistrate may appeal a decision of the review tribunal to the Supreme Court under the substantial evidence rule.
And is that prior to the publication of the public reprimand?
Yes.
Or after? Okay, I'll stop asking you questions, but I'm going to go try to at least see that part, because I just didn't see where it said you were entitled to it prior to.
I just pointed you to it. It's there on page 5 of the bill, those 3 lines where it talks about the right to appeal a decision of the tribunal of the commission, and we haven't changed any of that in the JR.
No. I don't disagree that this says that. I guess my question is, I don't know that this says that I have that right before the public reprimand is made public and not after, and you disagree with it.
That is current law. It's not housed in this JR, but that is current law. That is the way the commission works currently. Before the reprimand is made public, you have the ability to appeal.
Okay, thank you.
Thank you, Representative Jones. Members, please join me in supporting this JR. Last thing I will mention, Representative Wu mentioned that the vote in our committee was 6-5. 3 of those no votes have changed, and we'll be voting yes on the bill now, and so the real vote of our committee will be 9-2, and I'd ask that you join them and me in supporting SJR 27.
Question occurs, record vote, clerk ring the bell. Strict enforcement has been requested. Vote from your desk and vote for yourself. Have all members voted? Have all members voted? Have all members voted? 119 ayes, 17 nays. SJR passes. Chair lays out SB 6.